Guys, has the stream started? If yes, and if you can hear me, please do let me know. Okay, it started. Can you hear me, guys? Guys, can you hear me? Hi, hi. I am not late. I told you I have a class. The class is supposed to be till 8:15, 8:20. Just got done. And so now here with you all. Is the audio clear? All of you? Is the audio clear? Okay. Thank you so much. Bye bye. So, did you revise what we did yesterday? Did you guys revise? Hello, hello, hello. Good evening, good evening, good evening. So, did you guys revise what we did yesterday? You did? That's very nice. That's good. So, can we start with today's session? Good evening, good evening, good evening. So, can we start with today's session? I think wearing the glasses makes me look a little serious, no? I think I should wear it all the time, right? Good morning, Sashi. Good morning. Chalo, so yesterday we had done types of companies. How many of you tried solving questions on types of companies? How many of you? Oh, I look like Harry Potter. Nice. I don't mind looking like Harry Potter though. So tell me, how many of you actually tried solving at least one or two questions, writing one or two questions on types of companies? How many of you did that? How many of you actually did that writing of questions on Companies Act? I want to see that, yes, all of you a little quickly because we'll start with the class after that. You tried? Okay. Who else? Yesterday the energy was there. Today the energy is gone. Completely gone. Completely gone. Chalo, so let's actually move to the next part. We have a lot of things to cover and these things are very important also that we are going to cover. So instead of wasting our time, let's actually do it. That's good. That's good. Chalo, that's very good. So what we are going to do today is incorporation of the company. And when I say incorporation of the company, this is given under section 7, right? As of till now, I've never seen them ask specifically incorporation of the company ka question. I've not seen them ask. However, they do ask on penalty for wrong information. But anyway, it is there and we have to, because one thing that I've learned is institute can ask you any questions from any topic if it is there in your syllabus. So, moving on to incorporation of company. First of all, section 3 says that a company may be incorporated by 7 or more persons in case of public, 2 or more persons in case of private, and 1 in case of OPC. And such company may be a company limited by shares or a company limited by guarantee or an unlimited liability company. Now, when we talk about incorporation, the procedure of incorporation, for that we need the form SPICE Plus, simplified specified pro forma of incorporating companies electronically plus. And this form has 3 applications. Sorry, rather 4 applications. What is the first one? Application for name. Second, application for incorporation. Third, appointment of directors. Fourth, allotment of DIN. Now, along with SPICE Plus, I have to send some documents. So what are these documents that I send along with SPICE Plus? So what are the documents that we send along with SPICE Plus? The first and foremost, MOA and AOA, right? EMOA, AOA. Second is a declaration. Now there are 2 declarations which is given. The first declaration is given by the professional who is engaged with the formation of the company. He can be a CA, a CS, or a CMA, or an advocate in practice. And one other declaration will be given by any director, manager, or secretary. What? That we have fulfilled all the requirements of the act relating to incorporation. What? That we have fulfilled all the requirements of incorporation. Then second declaration is given by every director and subscriber and subscribers. What? First, I was not guilty of any offense in the incorporation or promotion of company. Second, while I was managing the company, I was not guilty of fraud or misfeasance or breach of duty. Third, whatever information is given, to my knowledge, such information is true and correct. Then after this is sent. Along with this, we also give for address for correspondence. If I have a registered office, that address is fine. If I don't have a registered office, I have to give some address where the registrar can correspond with me. So I have to give address for correspondence. Then I have to give details of subscribers like name, surname, family name, address, occupation, photo ID. Along with that, if my subscriber is a body corporate, right? If my subscriber is a body corporate, I also have to give SIN. Along with that, I will also give details of my directors. When I say details of my directors, what details of my directors I give? Name, same name, surname, family name, address, occupation, photo ID. Here a body corporate cannot be a director. So here we don't have SIN, but we have DIN. Then my director can be a partner of any firm, or he can hold shares of another company. So all the details of interest of my director in any other firm or body corporate, and his consent to act as director. So always remember, here there are 3 Ds. 1 document, 2 declarations, 3 details. First detail is details of address. Second details is details of subscribers and directors. Third detail is detail of interest of directors in any other body corporate. And it is filed with the ROC. If ROC is satisfied, the ROC will issue a certificate of incorporation and he will allot a SIN. When I say certificate of incorporation, the certificate of incorporation is an evidence that the company has been incorporated. If the company is incorporated by giving false or incorrect information, then there will obviously be a punishment. Obviously, it's false information is given, there would be repercussions also. So in that case, we have 2 situations. One is before incorporation, we come to know information is false. Second is after incorporation, we come to know. Before incorporation, company is not incorporated. So I don't have an option to punish the company. So before incorporation, I cannot punish the company. I can only punish the persons who have signed the document. After incorporation, obviously the persons will also be punished. The company will also be punished. So coming back again, before incorporation, if we come to know that the information given is false, then what will I do? In that case, the company, every person who has signed the document and has knowledge of what? Of the false information, shall be liable under section 447. We don't have to do section 447, but section 447 says you can have a minimum imprisonment of 6 months. It can go up to 10 years. After incorporation, if I come to know that the information given is false, first of all, every person who has signed the document shall be liable under section 447. So basic difference is, before incorporation, only people who had knowledge will be liable. After incorporation, everyone who has signed will be liable. So you become a CA, someone comes and says, please sign my document. Oh, you want my autograph, and then both of us will be photographed together. Don't do all these things. Got it? Now, if after incorporation, it is known that the information given was false, then obviously against the company also the tribunal will pass orders. 5 orders can be passed. First, it can pass orders for the management of the company. Second, it can make the liability of the members unlimited. Third, it can pass an order to strike off the name of the company. Fourth, it can pass an order for the winding up of the company. Other than this 4, if the tribunal feels any other order should be passed, tribunal can even pass that other order. But before passing any order, tribunal has to give the company an opportunity of being heard, and it should take into consideration the contracts already made, because it should not put the third party at a disadvantage. And only after that the tribunal will pass any order. I hope this is clear. I'm not going to waste much time here in this also, right? I'm not going to waste much time in this today. Can I move forward? Yes. Now, when the company is incorporated, a thin wheel called the corporate wheel comes between the company and the member. However, in some cases, this wheel is lifted. This is known as lifting of corporate wheel. I don't have a wheel, otherwise I would have showed you. It's lifted, right? Like if you cover the syllabus, you take out the syllabus like that. The wheel is lifted. So when I say the wheel is lifted, what happens is the company and member is taken as one. That means what? The member will be held liable or responsible for whatever the company does. So we have 4 cases here. The first one, generally in this section, it's more of judicial cases. And on those judicial cases only, we can say the wheel is lifted. Though we have done one statutory provision where the wheel is lifted. Section 7, where the company is formed by giving false information. Tribunal can make the liability of the members unlimited. There it is the statutory provision where the wheel is lifted. Otherwise, most of the cases, it is only statutory provisions. Judicial pronouncements. The first one, protection of revenue. The name of the case was Sir Dinshaw Manikji Petit. So what happened in this case was, this D had formed 4 companies. D had a lot of income from investments, and because of high income, he had to pay high taxes. So he made 4 companies, diluted the investments, and these investments were transferred to each of the company. And from this company, he was taking the income as a loan, which was never repaid. The court held the only purpose of forming these four companies was to avoid the payment of taxes. The wheel was lifted. That means what? The company was ordered to pay, D was ordered rather to pay the higher taxes, right? Then the next one is where the company is a sham or fraud. The name of the case was Guilford Motor Company versus Horn. So the employee was ordered by the employer that after quitting my job, you cannot deal with my clients. After quitting my job, you cannot deal with my clients. Now, what the employee did was, after quitting the job, he made a company, and through this company, he started dealing with the clients. Can we say the purpose of the company was only to deal with the employer's clients? Yes, the wheel was lifted. And when the wheel was lifted means the company was said that the company cannot contract with the clients of the employer. The next one, the company is formed to avoid welfare legislations. Workmen of Associate Rubber Industries Limited Bhavnagar versus the Associate Rubber Industries Limited Bhavnagar. Welfare legislations are basically welfare laws which is for the welfare of the society or a part of the society or a group of the people of the society. Here, the company, because it was earning high profits from an investment and because of which it had to pay high bonus, company, what they did was they formed a subsidiary company, and to this subsidiary company, they transferred this investment. And this subsidiary company was not doing any business. It was just holding that investment on behalf of the company. The court held that the only motive of this subsidiary was to hold the investment so as to show less profits in the main company's profits. So to avoid the payment of higher bonus, the wheel was lifted and the company was ordered to pay the higher bonus. The last one, to determine the true character of the company. The name of the case is Daimler Company Limited versus Continental Tire and Rubber Company Limited. In this case, here the company was not formed for any unlawful purpose, but still the wheel was lifted to determine whether the company is an enemy company or not. So this company was incorporated in England, but 90% of the shareholders were German. During World War, English and Germans were at war, and the company filed a case against the English debtors. In this case, the court lifted the wheel. Generally, members does not define the domicile of the company. But because the situation was such that we were in war, so because of that war situation, the court decided to see the members, and it saw that 90% of the members were German and the company was declared to be an enemy company. In normal cases, it would be an English company because it's incorporated in England. But because of that situation, the members, because of the domicile of the members, the company was also declared to be a German company and hence enemy company. Right? I hope all the 4 cases are clear to all of you. The basic difference, Ruben, injunction for what? What is the difference between strike-off? Strike-off is nothing but winding up without the process of winding up. But in strike-off, up to 20 years, the company's name can be put back into the registrar. So basically, the name of the company is removed from the registers of the registrar. It is not exactly wound up, but the existence of the company has come to an end. But 20 years ke andar, if I want, I can restore the name and it will again become a company. But winding up means winding up, complete winding up. Injunction for what, you asked me? I did not get you. Yes, 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 you can say that. Absolutely. You can say that. PG Films Limited, they wanted to, it was a English movie if I'm not wrong, but they wanted to register it in India as an American movie. The court held that since the movie is an English movie and the the production is also English, how can we register it as an American movie? So the wheel was lifted and the court held that we will only register it as an English movie. I hope it's clear. Can I move forward, guys? Moving on to the next one, Memorandum of Association. What is Memorandum of Association? Memorandum of Association means the memorandum originally framed and altered from time to time. This means every time I alter my memorandum, now the altered memorandum will be considered as the memorandum of the company. Now this memorandum has 6 clauses: name clause, registered office clause, object clause, capital clause, liability clause, association clause. Name clause tells us the name of the company and always ends with the words private, limited or limited. But if you are a government company, you need not use the word limited or private limited after your name. Registered office decides this states the name of the state of the where the company's office is situated. We don't give the address, but verification of address is given to the ROC. Then object clause tells us the purpose for which the company has been incorporated, and if we make any contract which is against the object clause, such contract is ultra vires and hence it is void. Capital clause decides the total authorized capital of the company along with division. That is, along with how much is the authorized capital divided into, as in how many number of shares and what is the value per share. Liability clause states the liability of the members, whether it's limited. If it is limited, is it limited by shares? Is it limited by guarantee? If it is unlimited. Association or subscription clause. This clause basically tells us, I mean, it's a declaration given by the subscribers that we are forming this company, right? And they, along with that, their name, address, occupation, their digital signature, PAN card, Aadhaar card, whatever, and the number of shares they are taking, that is given. I hope this is clear to all of you. Today, very dead you all are. I have a reason to be. You don't have a reason to be. You cannot be. So you should be answering a little more. Is it clear to all of you? Is it clear to everyone? In the exam, this portion you definitely may get one question from this portion. Okay, minimum one question you will get from this portion most of the time. Now, articles. What is articles? So basically, what is the difference between memorandum and articles? Memorandum tells you what the company can do. Articles tells us how the company will do it. So memorandum tells us the liability of the company towards the outsiders, whereas articles tells us the management internal, right? So articles means the articles as originally framed and altered from time to time. Now, whenever the company takes any decision, these decisions can be taken either by passing an ordinary resolution or by special resolution. What is special resolution? 75% minimum in favor, right? Minimum 75% in favor. Now, can I alter my articles? Yes, a company can alter its articles, and to alter the articles, the company needs at least approval of how many? 75%. That is special resolution. So, can a company alter its articles? Yes. Which company needs the approval of central government? Let's see how many of you put down. Which company needs the approval of the central government? Let's see how many of you put the correct answer. Okay. Exactly. If it's a Section 8 company, along for any kind of alteration whatsoever, I need the approval of the central government. Now tell me, can a normal company alter its MOA or AO? Can a normal company alter its AOA? Yes. For such alteration, I need special resolution. But it may happen that for one particular clause in my articles, I may put that for this alteration, I need the approval. So that means, let's say this is my articles. These are the provisions of my articles, right? Now, to alter my articles, I need approval of special resolution, 75% approval. But let us say for this clause, I said to alter this clause, I need 90% approval. So this is an entrenchment clause, right? This is an entrenchment clause. What it means is the rest of my articles will be altered only by passing a special resolution, right? The rest of my articles can be altered only by passing a special resolution. But to alter this clause, I need the approval of 90%, right? For alteration of this clause, I need approval of 90%. This is entrenchment clause, to provide that a particular provision of the articles shall be altered only by provisions which are more restrictive than special resolution. Special resolution is 75%. So saying that 80% consent, 90%, 100% consent. Can I say, guys, all of you will answer. Can I say 60% consent? Guys, can I say 60% consent? Tell me. Can I say 60% consent? Can I say 60% consent? Exactly. See what's given? It may contain entrenchment to the effect that specified provisions of the articles, right? Specified provisions of the articles may be altered only if conditions or procedures which are more restrictive, than special resolution are met or complied with. So it has to be something more than 75. Can it be 80? Yes. Can it be 90, 100? Yes. Now, how can I put this clause? This clause can be put at the time of incorporation. That is, at the time of formation of the company only, I can put this clause in my articles. Or I can put it as an amendment. For this amendment, if you are a public, any amendment of articles needs special resolution. So if you are a public company, for this amendment, you need consent of 75%. But if you are a private company, alteration of articles is special resolution. But to add an entrenchment clause, you need the consent of all. And whether you put it at the time of formation or you put it as an amendment, in either of the cases, you have to give a notice to the registrar. I hope this is clear to all of you. Guys, just put down a yes if it's clear to all of you. Hello, Benisha. Yes? Okay. Can we go forward now? Now, very important, one of the most important provisions of the Companies Act in your syllabus, Doctrine of Ultra Vires. What is Doctrine of Ultra Vires? Ultra means beyond, vires means powers. You remember the object clause. A company is authorized to do anything which is within the object clause. But if the company does any act which is outside the object clause, such a contract is ultra vires. Ultra means beyond, vires means powers. It is beyond the powers of the company and hence void. Right? It is ultra vires beyond the powers of the company and hence void. Now, can the body of the shareholders ratify it? No, it's beyond the powers, it's void ab initio. And when something is void ab initio, can you ratify it? No. So even the whole body of shareholders cannot ratify. That means even if all the members agree, still the act will always be void ab initio. The concept was laid down in the case of Ashbury Railway Company versus Ritchie. And if you're writing an answer on doctrine of ultra vires, make sure you write this case law. Okay? What are the consequences of ultra vires? It's void ab initio. Even the whole body of shareholders cannot ratify. Even a single shareholder can sue the company. The directors are personally liable in case of any liability. Now, ultra vires the directors, but intra vires the shareholders. The directors can take a loan, but with the consent of shareholders. That means directors can do only with the approval of the shareholders. That means shareholders can do, directors cannot do. In that case, it is the duty of the directors to take the consent. If they do it without the consent, it is ultra vires the directors, intra vires the shareholders, and the shareholders can ratify it. If the act is done ultra vires, but the money remains unutilized, the third party can sue the company for injunction. If the act is ultra vires, but the money remains unutilized, the third party can sue the company for injunction. If the loan has been utilized for any lawful debts, then that part of the debt which is used for, that part of the loan which is used for lawful debts, the lender, that is the person who lends the money, steps into the shoes of the debtors and he can recover that money from the company. Correct? Now, doctrine of constructive notice. What is doctrine of constructive notice? Now, constructive notice says that whenever you file a document under section 399, when I file a document, any document with the ROC, such documents becomes a public document. Public document means it's open to the public to go and inspect that document. And the public cannot say, oh, I did not know. It is your duty to go and inspect it before you make a contract. And if you have not inspected, you cannot claim any relief. So, when I say ultra vires, you would say, ma'am, how will the third party come to know what the company can or cannot do? So the third party has a right to go and check the documents. And whenever the third party checks the documents, he will know what the company can or cannot do. So doctrine of constructive notice actually gives a protection to the company against the outsiders. That outsider, if you have not read the document, it's your fault, not the company's fault. And now, even if you just mention, it's enough, unless they ask you to specifically explain the case. Okay? We had done this one question I had given you in the exam. I want you to tell me the answer to this, and then I want to write this answer actually. This one. Read the question, give me the answer. I'll share it. Please give me the answer to this question. Today, what's wrong? You people are also so less energetic, no answers coming. And also, many people are not there in the sessions today. Why? Okay. Nitika cannot recover the money. Anything else? I'm waiting, guys. See, when you talk about directors are personally liable, it's not in all the cases you can say that. You cannot sue the directors for injunction. The company has taken the loan. The company has taken the loan. You sue the company, not the directors. You sue the company, not the directors. Actually, don't have any document to write. Amount is utilized. Where have they given the amount is utilized? Nowhere is it given that the amount is utilized, na? This is gone. What happened to this? The screen is visible to you all, but nothing is visible to me. It's already shared, dear. Just 1 second. I don't know what's wrong with the screen. Oh, finally it has come. Just 1 second, guys. It's there again. Yes, whenever we write ultra vires, no, we should mention the this injunction thing also. We should. Sorry, doctrine of constructive notice we should mention, because otherwise how am I giving that third party is unaware that part? For that part we have to write about constructive notice. Okay? Mock test I'll be needing, but 1 minute. I think everything is gone. Just 1 second. Huh? So anyway, let's discuss this question number 4. So the object clause authorized the company to carry the business of trading in property in Gurgaon. Since the company was not doing well, the directors in a recent board meeting planned to diversify the business and enter into construction business. They borrowed a sum of 5 crores from Magnum Finance Limited, but the members of the company did not approve the decision of the board. Hence, the company refused to repay the loan. So this act, they had taken a loan, but the members never approved of it. So obviously what we have to write? We have to write about ultra vires, right? So as per the provisions of the Companies Act 2013, a company is empowered to do every act mentioned in the memorandum. Any act which is done outside the scope of the company is ultra vires. It was held in the case of Ashbury Railway Company versus Ritchie. Any contract which is ultra vires is void ab initio. Right, which is ultra vires is void ab initio. In case of a ultra vires contract, the following consequences will happen. Or in case of ultra vires, the following shall be the consequence. That is better English. Okay? First, contract is void, and so the third party cannot sue the company. Second, if any amount remains unutilized by the company, the lender can sue the company for injunction to stop the company from using the loan, right? Third, if any ultra vires loan is utilized by the company for payment of any lawful debt, then for such part of the lawful debt, the lender steps into the shoes of the creditor and can recover the money from the company. Right? Under section 399, if you don't remember, it is okay. Any document filed by the company with the registrar becomes a public document and it is deemed that every person dealing with the company has knowledge about it. Guys, are you there with me? Guys, are you there with me? Wow, this guy really spammed it. Okay. Now tell me, so this is our, now let's go back to the question. So, what is the recourse available to Magnum Finance? Can Magnum Finance recover the money? Therefore, Magnum Finance, tell me the answer. Can Magnum Finance recover the money? Debtor. Because the company was the debtor, but his money is being utilized, so he steps into the shoes of the debtor. Tell me, can Magnum Finance recover the money? I want to see that answer. Can Magnum Finance recover the money? Cannot recover. Why? Because it's ultra vires. No. Therefore, Magnum Finance cannot recover the money. However, Magnum Finance can. Can I say Magnum Finance can? What the hell? Seriously? Oh, I can block. Wait. Chalo. So now tell me. So, however, can I say Magnum Finance can sue for? I did. I did not know I could block, but I did. Can I say, guys, tell me. Guys, tell me. Can I say, I did. Can I say that Magnum Finance cannot recover the money because it's ultra vires, right? But can I say Magnum Finance can sue for injunction, the whole point, if the money is unutilized? Or can I say if the money is utilized for lawful debts, he will step into the shoes of the debtor? Can we do that? Can we write this? I mean, I've not written the whole thing because I've already written it above. Can I write this? Yes or no? Is it right if I put this? Is it right if I put this? Hello, Hana, to bol do. Is it right if I put this? Yes? In your answer, when I took the exam, no one wrote that injunction part. That was missing in all of your answers. No one wrote that lawful debts wala part. Right? No one wrote those two parts. Clear? Is it clear to all of you? Now, in our book, no, there is this one question. So, it's there in our book also. Okay? It's there in our material also. It's about ultra wires that it utilized. No, I did not watch Sayara, and I'm not feeling at all to watch it also. Have you watched it? Have you watched it? You remember this question is there in our material? And I remember we had done it in the class also. This question was there in the material. Do you remember it? Hello, hello, hello. So I want you to write this answer in the format. Okay? Clear? I want you to write this answer in the format. Everyone has gone, disappeared. Today, no. I'm not liking your vibes at all. No energy. It's like you are dying. I should be the one dying, but you are dying. I am alive and ekdam vibing. You guys are dying. Also planning something very interesting on quiz and all. I'll post about it today or tomorrow on Instagram. So planning on something. Oh yo, why thank you? Abhi to baki hai. So now moving on. Is it clear to all of you? Can I go to the next topic? I want that yes, please. Write that yes. Don't die. Don't let me die. Chalo. I don't want the answer. I want you to write it in the format. Okay? Try and write the answer. Yes, 3 crores can be recovered. 2 crores cannot be recovered. But I want you to write the answer in the format. Okay? I want you to write the answer in the format. Yeah, this is good. I want to see that, yes, you people are today. Brr. Now, indoor management. Indoor management basically protects the outsiders against the company. As an outsider, I have to see whether the company has an authority to do a particular work or not. But how the authority was not given is not, how the authority was given is not my concern. This concept was held in the case of Royal British Bank versus Turquin. Right? It was held in the case of Royal British Bank versus Turquin. And in this case, the court held that as an outsider, you only have to see whether the company has an authority to do a particular act or not. But how the authority was given is not your concern. So, if let's say a company has to pass a resolution and the company has not passed that resolution, as an outsider, I don't have to check whether the resolution was passed or not. My concern is to see whether company has the right to do the work. How it was given is not my concern. But because of this, a lot of people started misusing it. So they came up with these lochas where the rule of indoor management will not apply. You can claim indoor management when you are ignorant about the fact. When you know about the fact, how can you claim on indoor management? So you can only claim on the grounds of indoor management if you are ignorant of the fact. Second, if you are negligent, like going and buying some property from the accountant of the company, bro, accountant of the company does not have the authority to do that. So you are negligent here. So can you claim any relief from the company? No. Third, ayo, I don't know. MOA, next time pakka I will know. Can you claim any relief? No, it's your duty to know. And forgery, obviously all of you remember, my name is Hasina Bano, right? So in all of these 4 cases, you cannot claim any relief under the doctrine of indoor management. I hope it's clear. Next, what is a share? A share is a share in the share capital of the company and includes stock. When I say shares, shares can be divided into equity shares and preference shares. Equity shares, we don't have any types. What is basically what is equity shares, which is not preference shares, right? And when we say preference shares have preferential rights in the payment of dividend. That means first dividend will be paid to them and then to the equity. And they have a preferential right in repayment in winding up. That means in winding up, they will first be paid and then the equity shareholders will be paid. Equity shareholders, they have voting rights, and in some cases they also have differential voting rights. Nominal capital. Guys, do I really need to explain this concept? Guys, do I really need? Sure, I'll explain the indoor management. Indoor management, what actually is the concept of indoor management? Let's say the articles of the MOA of the company says, or the articles say that the company can do it. Okay, the articles of the company says company can do it, but with consent of shareholders. Okay? As an outsider, I have to see whether the company can do it or not. This I have to check. But do I have to check how the company got the authority to do it? No. As an outsider, my only concern is to check whether the company can do a particular act or not. But did the company pass the resolution for doing the act? Was the resolution properly given? That is not my concern. So as an outsider, I have to see whether the company can do it, but how the company can do it is not my concern. This is the concept of indoor management. Ultra vires means you're going against the powers of the company. The MOA has the object clause which tells us what are the powers of the company. If you do any act which is outside that power, it is void ab initio. Even the whole body of shareholders cannot ratify it. But if it is ultra vires, you have taken an ultra vires loan and the loan has been utilized for some goods or services, the third party cannot sue the company to recover that loan. But if the money is unutilized, the third party can sue the company for injunction to stop it from using that money. That means I have taken a loan which is ultra vires and the money is unutilized. I don't have a right on that money. So you gave me the loan, you can sue me to stop me from using this money. Second, if I have taken a loan from you and I have utilized it for some lawful debts, then it is like I don't have a right over this money. So it's like your money paid to the creditor. So you step into the shoes of the debtor and you can recover to the extent of the lawful amount paid. Chitra, is it clear to you? Chitra, is it clear to you? Chitra, Sheetal, is it clear? Any point you want to ask me before we wind up today's session? And I'm planning on something. Let's see. I'll put it on, Insta about that. Yes, they can stop and they can recover the money. Yes, they can. Any of you, before I wind up the session, do you want me to explain anything again? Let me do it before I wind up the session. Anyone wants me to explain anything? Injunction, basically when you're not supposed to do something and you're doing it. So you're breaching a negative clause. You're not supposed to do, you're doing it. I will sue you to stop you from doing that act. That is injunction. When you're not supposed to do, but you do it, I will sue you to stop you from doing that act. That is injunction. Yes, Chitra, I will be hopefully doing Indian Contract Act. Yes, hopefully I will be doing Contract Act also. What about that, Rishabh? What about that? Thank you so much, Soumya. Thank you so much. Yes, yes, Ritvik, correct. Or if the money is unutilized, then for injunction you can sue. If company is incorporated by giving false information before incorporation, every person who signed the document and had knowledge about it shall be liable to a punishment under section 447. After incorporation, if you come to know about the false information, every person who signed is liable under section 447, and company के against में the tribunal can pass any of the orders, making the liability unlimited, pass orders for the management of the company, strike off the name of the company, wind up the company, or it can pass any other orders it deems fit. But before any order is passed, the company must be given an opportunity of being heard, and also it should take into consideration contracts already made so that third party is not put at a loss. Prahlad, I am very sorry. I have no clue about, but we have online, like we have classes for CA final. Okay. Fast track, I don't know. So you can actually do one thing. You can call up the office during the daytime and they will guide you better. We do have classes for finals, but I don't know whether it's fast track or normal. So the people at the office will be the best people to guide you on this. Okay. Yes, in two cases, injunction and utilized for a lawful debts in these two cases. Guys, Companies Act is super easy, but you have to learn the provisions, because when I was checking your paper, provisions were not good. You were not very clear. You remember what ma'am taught. The good thing, what I felt good thing was they remember what ma'am taught. That is it. And that only you have penned down in the exam. Yes, Dikshit, if it is against the AOA, it can be ratified by the shareholders. Done, all of you? Anytime, anytime. August has started, and I hope August brings you all the blessings. I'm super excited because it's my birthday month. So another reason for me to be excited. Yes, 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 they can ask you direct questions. Dayanidhi, they can ask you direct questions. So I hope August month brings you a lot of good wishes, a lot of good health, and a lot of spirit to keep studying. Okay? So, yes, Rajnikant, you have told me. I will, if I can figure out, I'll figure out by this weekend and let you all know. Okay? When is the next class and next chapter? I have no idea about that. Okay? We will update you as soon as possible. It's on 23rd. Rose, okay, that's amazing. I'm happy to hear that. Yeshas material scanners, but it's enough. But keep reading again and again. The more times you read, the more times you practice, that's the key. So you need consistency and regular readings. The multiple readings, the more times you read, the better it will be for you. Okay? No, I'm not taking this advance happy birthday. Still 22 days left for that. I'm not taking it. Chalo, good night, guys. I'll see you all whenever is the next session, hopefully soon. I'll also put some scanner questions discussions. Okay? I'll also put some where I will help you identify. How will you identify what provision should come in that answer? I'll try and do that also for you all. Okay? Maybe not live recorded, whatever, but we'll try and do that also. Okay? And something new, as I told you, I'm planning. So if it works out, I'll be putting it on Instagram. Till then, bye bye, good night. Thank you so much, guys. Take care. Bye bye, bye bye. All the best, all the best. When is your birthday? 24th. Oh my God, Ambika, just one day before you. Bye bye bye. Just one day before you. Bye bye bye. Thank you so much. Thank you, guys. I have made a few audio podcasts. It's already there on Spotify. So if you're on Spotify, you search Nithika Bacchawat, you'll get it. Some are there. You give me idea which one you want, I will make it. My birthday is 23rd, Ambika. 23rd, just one day before you. So if I have already, it's already there. If you want any specific topics, you can message me. I'll make on that also. Okay? So bye bye. I am now ending this session. Any doubts? Okay, guys, tomorrow night I will be free. Many of you had messaged me your doubts, and honestly, when you message in the daytime, I'm in the class. Right now, I'm free. Now I'll go home. Right? So I am not able to answer your doubts. Tomorrow night I am free. Post 12. Anyone has any doubts, please send a message. I will reply to your doubts tomorrow. Okay? So bye 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 bye. Good night, good night, good night. Bye bye bye.